All right, everyone. It's about 3:05 p.m. So we're going to get started. As people join in, they'll be able to see and hear us as well. So first things first, I want to introduce myself real quick. My name is Corey. I work in the training and marketing department here at Nutmeg State Financial, and I'll be emceeing this event here today a little bit. I won't be speaking too much, but you'll hear from me here and there. I just wanted to lay out the details of how this will be organized today. So for those that already heard this, I'm sorry, but we'll be speaking myself, Rich Lang, and Matt Baldini. The three of us will be speaking throughout the time. You guys will be placed on mute for the time being. We'll allow some questions near the end, but please utilize the chat functionality in Zoom. I will say hello again on here. Here is the chat. So there is the chat functionality. Please ask your questions through there. And as Matt and Rich go through the presentation, you'll be able to have those questions answered. Like I said, near the end, we will open up some of the lines, unmute at least some of you for some questions as well. And to respect everyone's time, like I said, we'll make sure we'll answer in the chat as we get the questions. So I'm going to turn it over to Rich and Matt. I'll start with Rich, actually, if you want to give a quick introduction. I'm going to spotlight your video.
Hi, everyone. This is Rich Lang from Baldini Lang. Matt's going to kind of introduce the firm and start us off, and then we'll get into some of the details.
Awesome.
Great. And good afternoon, everybody. This is Matt. I think, as Corey mentioned, and as you'll see during this presentation, Rich and I are very informal. We like to consider ourselves the anti-law firm in that respect. And so I know we have certain constraints given the platform, the technology, in terms of asking and answering questions. I know we're going to be confined to the chat. But by all means, please fire questions away in the chat. Rich and I both have our chat screens up, and as questions come up, we'll answer those questions. If we don't get to your question, we can answer it at the end. And if for some reason, your question is fact specific or requires some further drill down, we're happy to jump on a call with anyone afterwards and answer any questions that anyone might have. So by all means, these kinds of presentations are always much more effective when there's audience participation. You all are kind of boots on the ground when it comes to dealing with the virus-related issues that you may be facing as an employer, and more specifically, the topic we're going to talk about today, which is the family leave and sick leave benefits, the expansion of those benefits through the Families First Coronavirus Act. So again, reiterate, ask questions, we'll answer them as they come up. And so with that, I'm going to share my screen and put the presentation up. And Rich, as Rich mentioned, we'll be going back and forth in terms of the presentation. So that good? You should all be able to see the introductory screen. Corey, good? Give me a thumbs up.
Yep,
excellent.
You're good to go, Matt.
Okay, great. Okay, so just a little bit about us and why Nutmeg asked us to participate on this. This is our background, but in summary, we act as general counsel for Nutmeg. We act as general counsel for some other credit unions across the state, other small, mid-sized businesses. Rich and I were both in-house counsel, general counsels at Fortune 100 companies. And so we went out on our own together a little bit more than 5 years ago, and just try to bring a very practical approach to supporting our clients. I think having been in-house kind of on the executive team of a business gives us a little bit different and better perspective in terms of counseling our clients. So it's in that vein that I do invite you to ask us questions or even jump on a call, after the fact, and we'd be happy to address any concerns or issues you might be going through. Okay, so I'm splitting the screen here because I have two monitors. So I'm going to try to look at the screen, but also control the slide that's up. So if I screw up, somebody, Corey or Rich, flag for me that I'm not, I don't have the right screen being presented.
We'll keep
So,
an eye out.
as I mentioned, we're here to talk about the Families First Coronavirus Response Act that went into law on March 18th, 2020, when President Trump signed it into law. And what it does is it requires certain employers to provide their employees with paid sick leave and expanded family and medical leave for COVID-19 related reasons. So prior to, we'll call it the FFCRA, prior to the FFCRA, there wasn't this mandatory sick leave for employers. That's really driven by employer policy. And then there certainly was FMLA in place for certain qualifying businesses, but if you were under a certain threshold, you didn't have to worry about it. And that's changed now with the FFCRA. So the FFCRA, it entitles certain employees to take up to 2 weeks of paid sick leave. And under the emergency FMLA, that amends, as I mentioned, the greater FMLA to have the FMLA apply to a broader swath of businesses that previously didn't need to worry about the FMLA now have to be concerned with the emergency FMLA. And it's also paid. There's supposed to be some tax credits on the back end, but the employer is obligated on the front end to front the paid portion of the FMLA, and there's a formula that goes along with it. And we'll talk a little bit about that.
All right, so I will take, excuse me, I will take over. I think we're one slide ahead, Matt. Go back one slide there. Back one slide. There we go. No, other way. There we go.
There we go.
So first we're going to talk about sick leave, then we'll talk about family leave. They go hand in hand, though, as we'll see. And kind of skip to the punchline. The reason they go hand in hand is the first 2 weeks of family leave are unpaid, but you can insert this sick leave there. So sick leave, who's eligible? It applies to all employees. And then there's categories that qualify as sick leave, and they're all related to the coronavirus or COVID-19 in some way. So I'll just quickly go through the 6. The reason why some are in black and some are in red is that there's different levels of pay and other things that go along with these. We'll get to that in a minute. So the first reason is that that an employee can get the leave is if they're subject to a quarantine order related to the coronavirus. That doesn't mean what we're all subject to being kind of stay at home here in Connecticut. This is an actual quarantine or isolation order due to the coronavirus. The second one is that the employee has specifically been advised by a healthcare provider to self-quarantine due to concerns related to coronavirus. Now, that's a phrase you probably could drive a truck through, and if you're an employee that doesn't want to work, that's probably the one that you would rely on the most. The third is you're actually seeking symptoms and experiencing symptoms and seeking a diagnosis. So we've seen this a lot. We've seen people that think they've got the coronavirus and that are seeking a medical diagnosis, usually by testing. Early days, the testing could take several days or a week or more. My understanding is currently that process is much quicker, but you can still have people out for a significant amount of time before they even know if they've got the coronavirus. The fourth category, and we'll see more about this when we get to the Family Leave Act. The fourth category is that, the category will be the one we'll see more about, the Family Leave. The fourth category is if you're caring for an individual who's subject to one of the first two categories. In other words, they're quarantining either due to a government requirement, or they're quarantining, self-quarantining because they have concerns related to the coronavirus, and have been advised by a healthcare provider to do it. Just because they want to self-quarantine is not enough to get them paid for 2 weeks. The fifth category is that the employee is caring for a son or daughter. It's very specific to this, son or daughter, if the school or place of care, the day provider, unavailable due to coronavirus precautions. So this pretty much applies to a single child of school age in the state of Connecticut, because I'm not aware of any school that's open. I think we're all dealing with having children at home of various ages. The sixth category is employees experiencing a substantially similar condition specified by the Secretary of Health or the Secretary of Labor, but I'm not aware that anybody that they've actually specified anything coronavirus that's available for this. And there's a note at the bottom here. There's possibility of subsequent regulations that would exclude healthcare providers and emergency responders from the definition of eligible employees. That was in case there was going to be a shortage of them. That has not been the case. And there's also the possibility for small businesses, and we can get to that in the Q&A if it applies to anybody. Q&A, small businesses with fewer than 50 employees would be in jeopardy because they would be complying with provisions. So let's say you're a small firm that has 1 or 2 employees, and the business would go down the drain if everybody was getting sick leave at the same time, or if you couldn't afford it. So next slide. We're still talking about sick leaves. So what do the covered employees get? So first of all, this applies to any employer that has fewer than 500 employees, and the employees get up to 2 weeks time. And this sick leave is in addition to anything that the employee is already entitled to. So if you've got a PTO program, you've got a sick leave program, you're one of those generous employers that lets everybody take as much time as they want, maybe some without pay. This supersedes all that, and they can get the sick leave under this act instead of that, or in addition to that. So then what do they get paid exactly? So it's paid at the rate of pay for the first few reasons on this previous slide. And if you remember, those were all had to do with the employee being subject to quarantine, either because the government said so, or their healthcare provider said so, or they're being tested for coronavirus or have been diagnosed with it. So in that case, they get their regular rate of pay, but it's capped at $511 per day, or $5,110 in the aggregate. So it's 511 times 10 days. $5,110 is the maximum an employee needs to be paid under this act. However, if it's due to the other reasons, because you're caring for somebody that is sick, or your child is home from work, or another reason that one of those secretaries have said is similar to coronavirus, if it's for one of those reasons, it's only 2/3 of the employee's regular rate of pay, but it's capped at $200 per $2,000 in the aggregate. Now we're going to talk about the family leave part of the act. And again, these work hand in hand because there's 12 weeks available under family leave, but the first 2 weeks are not paid. So, and there's a different condition. The employee has to be employed for 30 calendar days, and they have to have a specified qualifying need. And this is a very, very restrictive condition on who gets family leave. This is not like your normal family leave if someone's sick at home or someone's having a baby, anything like that. This is limited to, you need to have leave to care for a son or daughter under 18 years of age because their school or daycare is closed due to, or the child, or it's unavailable due to the coronavirus. So the usual kind of restrictions on FMLA, you have to be a certain size employer. The employee has to work a certain number of hours during the year. You have to have X number of employees within a certain radius. None of those apply here. Simply, if the employee has been employed for 30 days and they have to take care of their son or daughter under 18 due to the coronavirus making their daycare or school unavailable, then they're eligible for this leave. Now, there's, again, the possibility that subsequent regulations could exempt out both healthcare providers and emergency responders and employers that have fewer than 50 employees. And if they followed this act, it would jeopardize the business as a going concern. That's going to be a very high standard. There are rules we can talk about later, but that's not a standard that very many people are going to be able to meet. So again, these two things work in conjunction with each other, and if you hit the right categories, an employee could actually end up with 12 weeks of pay subject to certain caps. So what do they get? They get the expanded leave. The first 2 weeks can be unpaid. After that, they get paid. However, for the first 2 weeks, you could substitute in the sick leave, the expanded sick leave, or you could substitute in other sick leave that the employer provides on a regular basis. And we've already seen some cases where people have used up the 2 weeks of sick leave because they thought they were sick. Turns out they weren't sick. And then later on, they're wanting to use the family leave. And the question arises, can you get get it twice? And the answer to that's no. So again, the first 2 weeks can be unpaid, but you can substitute in other benefits. And then after the first 2 weeks, the remaining time is paid at 2/3 of the employer's regular rate, but it doesn't have to exceed $200 per day or $10,000 in the aggregate. So the benefits here are limited, and they're conditioned on, again, one condition. You're taking care of your son or daughter, they're 18 years old, and they cannot go to school or daycare because of the coronavirus. So that's the high-level overview of the Act and how those two provisions work together. We'd be happy to stop here and take any questions, or we've got some FAQs that we can walk through if there are no questions from anybody in the audience.
Thanks, Rich. So yeah, I'll utilize the chat functionality in Zoom. If anyone has any questions for Rich or Matt before we move on, I just sent a little hello. So for those listening on YouTube as well, same thing. The chat is open and working. So give yourselves a couple minutes to think of a question for these guys, and then we'll move on. Just send another chat in there.
And if you don't ask a question, we'll just assume we're being so incredibly thorough that we're just answering all of your questions.
That's what I was thinking too. I mean, if you're not asking questions, it means you're answering all of them, right?
Yeah, exactly. So yeah, so as Rich mentioned, we sort of the next phase of this presentation it's going to be a compilation of FAQs that some of which may address specific scenarios. The intent of it is that hopefully some of these address some specific scenarios that you may be experiencing on your end, and it may answer questions.
So Matt, I actually have a question from our YouTube. I have a viewer, Christy. She asked, can you please recap what size businesses this applies to?
Okay, so this applies to any business with less than 500 employees. So I'm assuming, businesses with 500 or more employees, probably, in most cases, maybe even have their own in-house legal counsel and probably don't need to participate on a call like this. So I would think, that most, if not all, the folks on the phone or on the line in the meeting that this now applies to you and your business. So anyone under 500 employees with, as Rich mentioned, certain potential relief for small businesses with 50 or fewer if certain conditions are met. But this is broad sweeping and impacts businesses that otherwise didn't have any sick leave requirements, which really applies to everyone, even the larger businesses, but also to which FMLA never even applied if you were under a certain threshold. That threshold from a federal level is 50 employees. So if you had fewer than 50 employees, you never really had to deal with FMLA, and now you're having to deal with mandatory paid sick leave and paid FMLA based upon the criteria that Rich described earlier.
Great. I actually have another question in there from Jamie. Are you going to be, it's just a kind of for the future of the presentation, will you be going over tax credit information?
At a high level, we're going to go over tax credit information. And the reason I say at a high level is because there's still, there's a lack of guidance that's been provided with regard to how that's going to work. The guidance that's been provided to date is you will be eligible to receive tax credits for amounts paid under the FFCRA. And we'll talk a little bit about the kinds of information that you're going to want to collect as employees are going out on paid sick leave and on emergency FMLA in anticipation of submitting those credits. But the mechanics of how the credits are actually going to work, that we're still waiting for details and guidance from both the DOL and the IRS.
Awesome. Thank
Those
you.
will be in the form of a payroll tax credit.
Yeah.
All
Okay,
right,
so
and-
as I mentioned, we're just going to go through, FAQs based upon FAQs received at the Department of Labor, just because we think that those are probably the most relevant and helpful. It's kind of an aggregation of questions that they've received from employers to whom, these emergency acts apply. If something hits directly on point, great. That's the intent, and other stuff maybe just FYI and maybe helpful down the road. So just the basics. This first one is just to reiterate, when does it go into effect, or when did the FFCRA go into effect? So it went into effect on April 1st of this year, and it is in effect through the end of the year, December 31st, 2020. At that point, it ends. So as far as we know right now, on January 1, 2021, there is no emergency paid sick leave, and there's no emergency FMLA. So we're just dealing with it for the remaining period of 2020. This goes to the question we just received, a little bit, probably not applicable for most, if not all, of the folks here, but I'm a private sector employer and I have 500 or more employees. Do the acts apply to me? And the answer is no. This applies to employers with fewer than 500 employees.
Yeah, the next question, I guess I'll take the next one. If providing the child care related paid sick leave and expanded family leave at my business with fewer than employees would jeopardize the viability of my business as a going concern, how do I take advantage of the small business exemption? There's actually at this point, there's some specific requirements that you want to try to document, but essentially you need to document the fact that it would really hurt your business. And again, it's a high standard. We'll get to some of the specifics on that later, but you'll need to file for the exemption and you'll have to document the reasons for that exemption. Question, part-time employees, you would go back, average number of hours in a 2-week period, and then you calculate it out that way. So you go back and do an average over the 2-week period, and then you would expand it forward and you would pay them based on that average. I think it's a 6-month average. And if there's seasonal employees, then you can kind of use a good faith basis to determine what an average would be over the course of a year.
Okay, when calculating pay due to employees, must overtime hours be included? So if you're dealing with hourly employees, non-exempt employees, the answer is yes. You're required to calculate for overtime hours. So if somebody takes sick leave and was expected to work 50 hours in the week subsequent to them taking the sick leave, then you're expected to pay them for those 50 hours. However, you are ultimately capped at 80 hours. So if for the next 2 weeks, there was an expectation that there would be 10 hours of overtime each week, resulting in 100 hours worked over that period of time, you're obligated only up to the 80 hours. So you pay them for the 80 hours. But you are supposed to calculate any overtime hours up to that 80 hours.
Remember, there's caps at 2/3 of pay and an overall cap. And I have not sat down and done the math. If somebody at minimum wage had 80 hours, would that hit the cap or not? I expect that it would, but I've not done the math on that.
Okay, can an employee take 80 hours of paid sick leave for self-quarantine and then another amount of paid sick leave for another reason provided under the Emergency Paid Sick Leave Act? So this is sort of the scenario Rich gave earlier. Somebody takes the sick leave because they think that they're sick, turns out that they're not. And then subsequent to that, there's something else that triggers an additional request. The answer is no, you can't double dip. So once you exhaust the 80 hours of paid sick leaves, that's it. At that point, to the extent that you qualify or an employee qualifies for the emergency family leave, they can go ahead and take that after the initial 2 weeks of the emergency family leave. Beginning week 3, that's paid family leave. But again, it's primarily limited to not if that individual is experiencing symptoms, but more focused on if they have a child at home that needs to be cared for, or somebody else at home that needs to be cared for, either because of a school situation or because of a sickness. So again, can't double dip. Once you exhaust the 80 hours, that's it, it's exhausted.
On the flip side of that, if you gave somebody 2 weeks off with pay before the act was effective, they're still entitled to the 2 weeks under this act. All right. Should I take the next one, Matt?
Yeah, I think the next one's you.
If an employee is home with a child because his or her school or place of care is closed or the child care provider is unavailable, does an employee get paid sick leave, expanded family medical leave, or both? How do they interact? Again, as we mentioned earlier, first of all, you get paid at 2/3 of your regular rate of pay up to the maximum. But the Family Leave Act, the Expanded Family Leave Act, gives you 12 weeks, but the first 2 weeks aren't paid. But the sick leave gives you 2 weeks that are paid. So you would take the sick leave first, and then you would take the family leave, and that'd be 12 weeks of paid leave total. Next one. Can an employer deny paid sick leave to an employee if that employer gave that employee paid leave for a reason identified in the Emergency Sick Leave Act prior to the act going into effect? So this is again the flip side of the if they got paid in full before, do they get paid again? The answer to that was yes. In this case, the answer is no. The employer can't deny that employee getting paid just because they paid them for the same reason prior to the act going into effect. So in effect, you start fresh on April 1st.
Okay, next question is, all leave under the FMLA now paid leave? So the answer is no. So the expanded FMLA is purely COVID-19 related. That's the only way that FMLA triggers a payment obligation on behalf of an employer that's covered under the emergency FMLA. Otherwise, the old FMLA rules apply. I mentioned earlier, those have very specific requirements. You need to have 50 or more employees. The employee needs to have been employed for at least 12 months and needs to have worked a minimum number of hours. It's 1250, and it's unpaid. And there's certain disability potentially that goes along with it, depending upon the reason for FMLA. But for purposes of this act, there's only paid FMLA now if it's really triggered as a result of an employee who must care for a child whose school or place of care is closed due to COVID-19 related reasons. Okay, what records do I need to keep when my employee takes paid sick leave or expanded family and medical leave? So this goes to what we discussed earlier a little bit, just about the requirements or the anticipated information that we expect will be needed related to the tax credits. So again, some of this will be intuitive, but to the extent you have somebody requesting sick leave or expanded FMLA leave, you want to get obviously the name of the employee, the date for which the leave is requested, the reason for the leave, a statement from the employee that he or she is unable to work because of whatever particular reason. If your employee requests leave because he or she is subject to a quarantine or an isolation order, or to care for an individual subject to an order, should additionally document the name of the entity that is issuing the order. For the most part, it's just going to be the state of Connecticut. If your employee requests leave to self-quarantine based upon the advice of a healthcare provider, or to care for an individual who's self-quarantining based upon such advice, you should document the name of the healthcare provider who gave the advice. If your employee requests leave to care for a child because of a school situation or a daycare situation, get the name of the school or the daycare. You just want to be able to connect all of the dots associated with the leave request so that, and keep them in your records. I strongly suspect nobody's ever going to ask for them, but you want to have them in your records for audit purposes, so that when you apply for the credit, however that's going to happen, and again, those details are still forthcoming, that you'll have the backup documentation associated with the credit request. So as much information as you can regarding the who, what, why, where, and when, put it in the file and hold on to it until more of the detail comes out about how the credits are going to work.
Before I do the next question, Corey, are there any questions?
Yeah, I actually did have one that came through private through YouTube. Question going back to the minimum wage, it was coming from YouTube, was when you go between below the 2/3 wage, you can't go below minimum wage, correct?
In other words, if they're getting minimum wage and they get 2/3 of their normal wage. If they're at minimum wage currently, they would get less than minimum wage, I believe.
Okay, so it can go below.
Yeah, and keep in mind that this is paid leave, paid FMLA that prior to pandemic nobody was entitled to, right? So it's not, it's intended to supplement in a scenario in which previously nobody would receive any benefits.
Awesome. Yeah. All right, while we got a little pause here, any other questions in the chat? Let's look on YouTube. There's a link. Looks like, again, you guys are just doing such a good job.
Yeah.
There you go.
You have everyone speechless.
Yeah.
All right, I'll take the next question. If an employee is unable to telework, I guess that's just a word now that we use.
Yeah, I think so, yeah.
Is that employee entitled to paid sick leave or expanded family and medical leave? So another way of asking, if during that sick leave period and they could telework, do they get paid sick leave? The answer is no. if they can work. Now, if they're too sick to work and they're self-quarantining or they're seeking diagnosis and they can't work despite the fact that telework is available to them, then they would be entitled to the paid leave. And then for we'll say the 10 weeks of paid family leave, if they are able to telework with the children at home, then they don't get paid the paid leave. They would just work like they normally work. But if you can't work because your children are home, then you do in fact qualify for the family leave. So it's kind of irrelevant whether it's telework or it's remote work or it's the usual kind of work. The question is, can you work? And if you can't work for one of these reasons, then you get paid. All right, next question. Can an employee take expanded family and medical leave intermittently while his child's school or place of care is closed or his child care provider is unavailable due to COVID-19 related reasons if that employee is not teleworking? And the answer to that is yes. So we're seeing a lot of employers becoming very flexible. They're letting people work some days in the office, some days they're teleworking. A lot of employers are trying to keep people in groups. So the same 2 or 3 people work together every time. That way, if somebody gets sick, they haven't contaminated 10 people, they just contaminated 3 or 4 people, and they can kind of monitor that. So if your employee allows you to do it, you can use this leave to kind of supplement time that you may not be able to work. And then, of course, it's at the reduced rate. But the benefit to the employer, of course, is that you're getting the tax credit at the end. And again, you got to keep records showing, what you're paying for regular work and what you're paying for family leave.
Okay. If an employer closes a work site on or after April 1st, but before an employee goes out on leave, can that employee get paid sick leave and or expanded family and medical leave? The answer is no, right? So the paid sick leave, the expanded family and medical leave assumes that there's work to be done. And this will be a theme in several of the questions coming up. To the extent that there's no work to be done because a branch has been closed or a particular operation has been closed or the business is shut down because it's non-essential or there's been a furlough. If there's no work to be done, then the sick leave and expanded family medical leave is not triggered. And that applies, and again, I'm probably jumping ahead and addressing some of the questions that are forthcoming. That applies even if an employee is in the middle of sick leave. Let's say they're out 1 week and with an intended 2-week duration of sick leave, and the business shuts down for COVID-related economic reasons. At that point, once the business shuts down and there's no work to be done, the paid sick leave terminates. And at that point, that employee is immediately eligible for unemployment. And similar to what Rich just described about, the employers being flexible with employees in terms of working arrangements, and which is really being endorsed by the Department of Labor. They really want employers and employees to try to work together and figure out some of these scenarios that haven't been addressed by the Act or the Department of Labor as of yet. So similar to that, the federal government and state governments have given the Department of Labor wide berth in terms of unemployment coverage. So scenarios that were previously not eligible for unemployment coverage now are. And the government, and we are counseling our clients to communicate to their employees, almost under every circumstance that's related to a lack of work, as long as you're not receiving these kinds of benefits, because you can't receive these benefits and receive unemployment. But to the extent that there's a reduction in hours or furloughs or, layoffs or whatever the case may be, the employee should make a run at unemployment coverage, because those are being handled on a case-by-case basis, and there's much more flexibility with regard to those benefits, and those benefits have been enhanced as a result of the virus.
Yeah, and in fact, if you're under a certain salary per year or a certain income per year, you're better off with unemployment benefits with the $600 per week additional.
Right.
Right.
Yeah. Yeah. Okay. If an employer closes a work site while an employee is on paid sick leave, this is the issue I just addressed. So employees out on paid sick leave, and in the middle of that, a work site's closed. That's the point at which the paid sick leave terminates and transitions over to an opportunity to receive the unemployment benefits.
So I think a lot of these are very similar. So if an employer's open but furloughs an employee on or after April 1st, can that employee receive paid sick leave or expanded family and medical leave? Again, the answer is no. And early on, Matt and I were telling employers they really should be considering furloughs to avoid some of these requirements before they came into effect. But essentially, if you're on furlough and you're doing it right, employees are eligible for unemployment benefits.
And just to make sure everyone understands that a furlough is nothing more than a temporary work stoppage, so that employee continues to receive any employer provided benefits. Those continue throughout the furlough period, but the employee is also eligible for unemployment benefits during that furloughed period. And with hourly employees, it's immediately triggered for any period of time in which they're not working. For salaried employees, exempt employees, they're only eligible to receive unemployment benefits for a whole week in which they do not work, a whole work week in which they do not work. So if they've worked a portion of a week, they are eligible to receive, or they should receive, their salary for that work week. So you need to make it a clean break, and it needs to be absolutely no work, no checking of emails, no checking voicemails during the furlough period. And the period of time within which you need to bring employees back who are furloughed, is a little bit loosey-goosey. It's tough to project given the current circumstances. Some of our clients are really tough to project when they may bring back furloughed employees. We're counseling our clients that, you can give them a good faith estimate in terms of when that will be, but have an open dialogue, check in with them if things are going to change. Generally speaking, the Department of Labor is understanding that furlough periods can change, and I would think given the current circumstances, they're going to be even more understanding. That said, it can't be for a year and a half. That won't be considered an actual furlough. And you also obviously risk the possibility of an employee who's on furlough going and getting another job. But that's the case, frankly, if they were on furlough or they were at work, assuming that they're an at-will employee, which the overwhelming majority of employees in Connecticut are.
As an aside, Matt and I worked at the same company during the Great Recession and were furloughed. Best 2 weeks off I ever had. They can't email you, they can't call you, they can't come by your house. I never had such a great 2-week vacation. The next question, I think this next question is very similar to what we've asked before. If the employer is closed, you can't get sick leave or expanded family leave. Probably should move on to that.
Yeah, Corey, did you have a question?
Yeah, there's a question in chat from Florence. It's from the last previous time. Is this for exempt or non-exempt or both employees?
Furloughs?
Yes, from the last slide.
Both. Yeah, it applies to both.
Awesome. Thank you.
Yeah, and you just one of the other benefits of, again, as Rich mentioned, we've been approached by clients who have considered both layoffs and furloughs, and obviously layoffs are different than furloughs in that you're actually severing the employment relationship. There is no continuation of benefits. You're terminating the employee without any promise to bring them back or promise to rehire. That's not to say you can't rehire them down the road, but there's a little bit more finality to it. So we've been encouraging our clients, if they can, and given the circumstances, to go the furlough route. You know, the additional benefit of a furlough is, you know, you obviously have an employee that you've invested in, you've trained. Presumably they know their job, they know how to do it, and there's a cost associated with having to start that process over again. So that's just another reason to consider furloughs as this situation continues to unfold.
Okay, next slide.
So if an employer reduces an employee's scheduled work hours, can that employee use paid sick leave or expanded family and medical leave for the hours that employee is no longer scheduled to work, right? So if an employee is a full-time 40-hour-a-week employee and their schedule is reduced to 20 hours a week, can they use paid sick leave or expanded FMLA? The answer is no. So again, paid sick leave, expanded FMLA applies only to those specific scenarios in which the work is available, but the person can't work for the reasons outlined in each of the leave scenarios that we talked about earlier. There is, however, as I mentioned, you know, a relaxed approach with regard to unemployment benefits. There is an opportunity potentially to collect unemployment benefits based upon a reduction of hours. And again, we're encouraging clients to tell their employees, take a shot at it, file the application. Given the flexibility, there's a chance if you have a reduction in hours that you may be able to get partial unemployment based upon that reduction in hours. Can an employee collect unemployment insurance benefits for time in which that employee receives paid sick leave and or expanded family and medical leave? A little bit different approach to a similar theme. The answer is no. One or the other. Either they get the paid sick leave and the expanded FMLA, or they seek and receive the unemployment benefits. You can't get both.
I'll take this one. If the employee elects to take paid sick leave or expanded FMLA, must the employer continue coverage? Yes. Short answer is yes. So all the benefits continue. However, the employee has to continue to contribute. They normally would contribute to that plan. If I'm an employer, may I use the paid sick leave mandated under the new law to satisfy paid leave entitlements that an employee may have under my paid leave policy? The answer to that is no. So again, these are in addition to your typical paid leave policy, and you cannot require your employee to take benefits under your company policy before they get the benefits under the Act. Again, assuming they qualify for the reasons set forth.
Okay, this one makes my head hurt, and I was hoping it would be Rich's slide, but it's actually my slide. So if I'm an employer, may I require an employee to take paid sick leave that he or she may have under my existing paid leave policy concurrently with the expanded family and medical leave under the Act? So Rich and I actually were talking about this before the presentation, just because I find the question and the answer a little bit confusing. But where we ended up is, if you're an employer and you have your own paid leave policy, at the end of the day, you can apply that paid leave policy instead or in lieu of the benefits we've been talking about, as long as it meets or exceeds the minimum requirements. However, you're not going to be eligible at that point for the tax credits, right? So if you're an employer and you have existing paid leave policies, you may want to think about amending those policies, immediately while this is all going on, to simply say these policies only apply to the extent that there's no corresponding, federal or state regulation entitling an employee to leave, right? Because then you don't have to worry about whether your policy gets triggered versus what we're talking about here, and you'll make sure that you're completely eligible for the tax credits. So they can.
At which point your policy becomes something of a supplemental policy on top of the federal law.
Right. Okay. Lots of employers kind of going above and beyond. So if I want to pay my employees more than they are entitled to receive for paid sick leave or expanded family and medical leave, can I do so? And can I claim a tax credit for the entire amount paid to them? You absolutely can do more. Well, a lot of our clients are, but you cannot seek the tax credit associated with anything additional you do above and beyond.
The next question, really, when it says the right to return to work, that's somewhat misleading. That makes it sound like they can get sick leave and get paid. The right to return to work, I'll use my air quotes here, is a term of art under the FMLA. It means that if you take this kind of leave, do you have the right to get your job back at the end of that leave? And the answer is generally yes. Now, if your job has been eliminated, your position has been eliminated, that might be an exception to that. And there's some other exceptions, but generally speaking, you can't be fired for taking this leave is essentially what the answer is to this question. Does an employee qualify for leave for COVID-19 related reason, even if that employee has already used some or all of his leave under the Family and Medical Leave Act? I don't think this is going to apply to most of our small businesses, but you get, let's see, I believe you get the 12 weeks regardless of FMLA, but we've not looked at that this closely. Matt, have you thought this through for larger businesses that are already subject to the FMLA?
I think the way it simply works is to the extent that any portion of FMLA, basic FMLA, has been used, you don't get to double dip here, right? So if a larger employer has an employee that exercised certain FMLA rights, non-COVID-19 related, in February of 2020 and used 6 weeks, you don't get an additional 12 weeks on top of that in 2020. You only get the remaining amount under FMLA. This Emergency FMLA Act simply expands the scenarios under which employees are eligible for FMLA, and also expands the employers who have to honor the FMLA and obligates everyone to pay for it, whereas under the regular FMLA, you're not obligated to pay for it.
All right. So in effect, you cannot double dip on the 12 weeks. You get the 12 weeks. Okay.
So we're backing up here. It's just 2 minutes before 4, Corey, and we have, we can go for a while longer, but why don't I pause here and see if there's any questions? And I know folks have some hard stops.
Yes. So, and just, I know I said it in the beginning, but just so everyone's aware, that's on the live stream on YouTube or here on Zoom. This video has been recorded, and we'll be releasing it on our social media platforms, as well as I know Rich and Matt will be sharing that with you so you can share it as well. So if you need to catch back on any of the questions that were asked or need to share it with anyone that you think would benefit from it, we will be uploading this video later tonight to our social media channels. So you have the ability to rewatch at any time and pause and take notes if need be. So I will again open up into the chat either on YouTube or on Zoom for any questions.
And as you're waiting for that, but here's our contact info. Take it down. You know, a lot of these scenarios are very fact specific or unique. Feel free to reach out to Rich and or me if you have a particular scenario. As I mentioned at the outset, we've been on the inside of different organizations. We understand sort of the practical aspect of a bunch of this. If there's a way, we can help you work through a particular unique situation, by all means, feel free to reach out to us.
Yeah, and I will have Matt and Rich's contact in the social media posts as well, so you can find them directly from those posts or from this video as well. So you don't have to go searching for it through this video. Great. So looks like I got no questions on Zoom or on YouTube. So Matt, Rich, any final thoughts? Anything else you'd like to share?
No, I mean, obviously unprecedented times, right? And it's been incredible, at least among our client base, just to see employers, our clients reacting and responding to, just an incredible situation with the best interest of employees and customers in mind, and kind of everyone chipping in. So I think if we all approach it from that mindset, hopefully there's light at the end of the tunnel here, and things will be getting back to normal sooner rather than later.
Agreed.
Yep. Thank you, everybody. Feel free to reach out to us, as Matt said. We're happy to chat with you. Thank you.
Thank you, guys. We will be hosting another webinar in about a week, so stay tuned to our social medias for that. So have a good weekend, Thursday, Friday, Saturday, Sunday at this point, everyone, and stay safe.
All right. Take care.
Bye.
Bye-bye.